everybody. We are here to talk about some recent goings on in the Travis Scott Astroworld events development. I did want to just point everyone's attention to the fact that, let me turn this, to the fact that I have already made, let me know if this volume is good for y'all. I know I had some issues on the last one. I already made a video about Travis Scott's incident, right? And at the time, the video just came out this morning. I'm sure this case is going to be developing. What I talked about was who could actually potentially be held responsible for the events in a criminal setting. Now, what we are going to be talking about in this live is actually civil cases. So these do not pertain to the city or the country or the state or anything like that pressing charges. This actually pertains to a private civil incident. So what we're going to be reading are two lawsuits that I downloaded myself from the Harris County District Court office. Now, I did pay $32 or $33 for these filings, but I will try to make them available. I'm saying try because it just depends if I remember to make them available on my Google document, linked in the description below, Google Drive, whatever, so that y'all can actually look at them yourselves. Okay. Oh, thank you to X Lexi. So there are two lawsuits, okay? One of them has already been reported on by Billboard, the Souza lawsuit. Now, both of these, I think, were filed on Saturday, November 6th. So, somehow they were filed on the same day that the incident happened? Oh, no. The incident happened on the Friday, right? Okay. So the first one I'm going to go through, I think it's going to be a little bit shorter. It's just a petition and a temporary restraining order. So let me share my screen with y'all so you can see that. And we'll just jump right into that one. It's going to be a little bit shorter. Okay. Okay. So y'all should be able to see it now. Hold on, let me just show y'all this. I have this space heater on and I'm burning up. Give me 1 second, sorry. Does anyone else have to have a space heater under their desk? Okay, here we go. Okay, so this is the original, this is called Original Petition. This one was filed by someone called Christian Guzman. Now, Christian is just asking for a temporary restraining order. And I say just because we're going to get into a second complaint here in just a moment where they're asking for a little bit more relief. So let's just read through this one. Thank you, Jordan. Oh, thank you. Connecting the dots. Yeah, exactly. Lou Taylor. Exactly. So Christian says that they would like a temporary restraining order restraining Live Nation Entertainment, NRG Energy, that's a funny name, NRG, NRG Stadium, and Harris County Sports and Convention Corporation from damaging, modifying, altering, selling, or disposing of any evidence of negligence at NRG Park during the Astroworld Fest. Okay. Plaintiff, that means the person suing, Christian Guzman, is an individual and citizen who resides in Houston. Defendant Live Nation was the promoter for the festival and is a New York Stock Exchange publicly traded company incorporated under the laws of the state of Delaware. Defendant in RG. So this part you just have to tell where each person is or entity is from to make sure that you actually do have jurisdiction there. Okay, then we have venue is proper. Okay, so here's their request. Mr. Christian is a Mr. Mr. Guzman requires injunctive. Y'all's comments are funny. Injunctive relief from this court to preserve material evidence, which at this time is in jeopardy of being discarded, altered, sold, or destroyed. So, this is called an injunction. Sometimes referred to as a preliminary injunction. So what it actually is a plaintiff in a case, in this case, Mr. Guzman, goes to the court and says, look, I have reason to believe that these people are going to start throwing stuff away, shredding documents, shredding throwing things away, deleting, maybe trying to cover their tracks. So I'm asking you, Mr. or Miss Judge, to tell them not to do that. And if they do that, later they're going to get in trouble for it, right? So that's basically what an injunction is. So then they get into the story a little bit. On Friday, November 5th, 2021, Christian Guzman attended Astroworld Fest 2021 at NRG Park, which was put on by Live Nation Entertainment, Inc. The event was on the property of and or under the control of NRG Park, aka NRG Stadium, and NRG Energy Inc., Harris County Sports and Convention Corporation. During the concert, there was a surge of uncontrolled people pushing through the crowd. The pushing soon became chaos as people were stampeded and trampled on. It is believed at this time that at least 8 people have died and hundreds of others were injured. Now, I've heard reports that it's up to like maybe 10 or 13 people. So it's even higher now, I believe. Mr. Guzman was pushed. Thank you so much, Naseeb. Aw, you're so nice. Looking at y'all's comments. I get so distracted, but I do love reading them. He was pushed to the ground and trampled, which has resulted in a significant back injury. So this is one of those concert goers who was injured, according to this complaint, or actually according to this request for a temporary restraining order or a preliminary injunction. Okay. During this time, the security, so I'm assuming during the time that he was pushed to the ground and all that, the security for the concert failed to maintain order. There are numerous videos showing people dancing on top of police vehicles as the police were attempting to control the crowd. Videos of bleep bleep being crowd surfed to medical attention and numerous comments about the medical staff being undertrained and not provided with sufficient equipment. All the while, the show went on. Well, it's really, I don't mean to laugh. This is a very serious tragedy. And I do not mean to demean or belittle, but it's sometimes my reaction to really heinous things is to laugh because it's like either that or like cuss someone out. So it's like, I don't mean to laugh. This is not a funny situation at all. But like Travis Scott up there just singing his songs, like all this chaos and mayhem is going on. Like, I just can't, it doesn't process in my mind. Like, I don't know how that works. It doesn't process in my mind. Okay. All the while, the show went on with Travis Scott continuing to perform, even after stopping the show because he saw people that needed help. Okay. Mr. Guzman. Okay. So we're on to Ivy, I think is 4. I do not do Roman numerals well. Mr. Guzman requests that this court sign an ex parte temporary restraining order, which basically would restrain Live Nation Entertainment and these other companies and entities from damaging, modifying, altering, selling, or disposing of any of the following. So this lawyer for Christian, for Mr. Guzman, is giving exact parameter, exact things that he or she doesn't want them to destroy or dispose of because this lawyer anticipates needing it for a lawsuit. Number 1, videos or pictures that were recorded, including drone footage. Number 2, any social media posts from any social media posts from November 5th or 6th. So I saw some of y'all in the comments before the live stream started saying that Travis Scott already has deleted perhaps, and listen, this might be fake news. I'm just telling you what people said in the comments. So I have not done the research to fact check this myself. If someone has, please post it below. But I was told that Travis Scott himself maybe actually tweeted out to his fans to sneak into the concert. And if that's the case, that could have contributed to those extra people who were not accounted for and maybe there wasn't enough security for. I don't know. I'm not making any speculations. I'm just thinking of that while, any social media posts. So now people are saying, okay, he deleted those posts. So this is exactly why, if that happened, exactly why you would file an order like this to say, hey, stop deleting stuff. We're going to need that for a lawsuit and you're trying to cover up evidence, right? Number 3, any information about employees or contractors that were working as security or medical professionals, including employment files. So they don't destroy any footage, don't destroy any information about who was working, who your employees were. Number 4, any and all receipts for medical equipment that was provided. Any policies or procedures about crowd control, policies or procedures about providing medical assistance, any records about attendance, any records about crowd control devices used. I don't know what that is, but it seems like maybe like, I don't know. Well, I guess that could be like a barricade, right? But I'm thinking like tear gas and stuff. But I don't know if like private, well, I guess police were there. Interesting. I don't know. I'm just thinking out loud. Any incident reports? I'm not deleting any of those. Any witness statements and any reprimands for employees of defendants. Okay, so they're saying don't delete any of this. Don't throw it away. Don't get rid of it because we need it for court. And Judge, Your Honor, please tell Live Nation and the other parties we mentioned not to delete any of this or get rid of any of this because we need it as evidence. And they shouldn't be deleting or getting rid of any of this anyway. But I do like that they went ahead and just, Mr. Guzman went ahead and had his lawyer file this just to be on the safe side. Okay, number 5, plaintiff's original petition and request for jury trial. Christian Guzman brings this cause of action against Live Nation Entertainment and all these other companies. And this is what he wants to show. The discovery level. Plaintiff intends, that's Christian, Mr. Guzman, intends to conduct discovery in this matter under level 3 of Rule 190 of the Texas Rules of Civil Procedure. And plaintiff seeks an amount exceeding $1 million. So this lawsuit is for over $1 million, just this one victim of this tragedy. Facts and legal claims. Based on the facts described above, plaintiff would show that nothing plaintiff did or failed to do on the occasion in question caused or in any way contributed to the cause or occurrence. So this is a kind of common notion in the law where if you took on a dangerous activity voluntarily and you get hurt, you might not get as much money as if you didn't actually participate in that dangerous activity. And so this is saying, look, this guy didn't do anything. They're not going to come back and say, oh, Mr. Guzman was one of the ones jumping on the cop car. The lawyer's saying, you're not going to find that out. He was just standing there minding his business, essentially, right? To the contrary, the injuries to him were proximately caused by the negligence of the defendants, jointly or individually. Defendants' failures, so Live Nation and all them's failures include, sorry. What page is this? 5, right? I just don't want it to be pink. Okay, there we go. Defendants' failures include, but are not limited to, failing to control and supervise the crowd, failing to provide an adequate number of security personnel, failing to provide properly trained security personnel, failing to provide sufficient equipment for security personnel, failing to provide an adequate number of medical professionals. And again, if defendants were encouraging people to sneak through a back entrance or something like that, then they had no way to know how many people would possibly be there. And so how could they possibly know how many medical professionals they needed? Failing to provide proper crowd control policies and procedures, failing to prevent a stampede from occurring and bleeping at least 8 people and injuring hundreds of others and the ensuing chaos. The injuries sustained by Mr. Guzman was proximately caused by the negligence and negligence per se of Live Nation. Defendant is liable for the actions or inactions taken by the on-site staff through the principle of respondeat superior. Y'all ready for a law lesson here? Anytime you see something in italics like this, per se and respondeat superior, that means it's a Latin word that you're looking at in this legal filing. So negligence per se is, so in the law, whenever you need to prove negligence, there are 4 elements. You have to prove that there was a duty that the defendant actually owed to a certain person or a certain thing. Duty. You have to show that that person or entity breached their duty, right? So duty, breach of duty. You have to show that their breach of their duty to you or to the to the defendant actually caused duty, breach, causation, caused some harm to happen. And then the last element is that you have to show harm. Okay, duty, breach, causation, and harm are the notes for negligence. And thank you very much to Professor Jacques Delisle for making sure I will never forget those 4 things. Interestingly, Travis Scott's name is Jacques as well. So duty, breach, causation, and harm. But negligence per se adds an even extra, like it makes it almost easier for you to prove negligence per se, because it's just so brazen and so obvious that this person had a duty and they completely knew exactly what was going to happen. It was totally foreseeable. Anyone could have called it. Just completely, grossly, terrible, negligent, right? And then what they're suing under respondeat superior is the notion of legal liability of an employer for something that their employee has done, right? So you ever heard your boss before say like, oh, you don't do that because if you do that, I could get sued. That is that notion of respondeat superior. So Mr. Guzman is saying, look, all your little security staff and medical personnel and all them, you're liable for what they did because you didn't train them enough. You didn't provide them with everything they needed, et cetera, et cetera. Further, in addition to the previous facts and claims, each defendant was negligent in hiring, training, and supervising employees, and that was a proximate cause of the stampede and plaintiff's injuries. So he's on that duty, breach, causation. He's on that third element, causation, right? They caused it, right? He's trying to prove it already here in his complaint or in his restraining order. Each of these failures, individually or combined, led to the injuries suffered by plaintiff. That's Mr. Guzman. Defendant's grossly negligent conduct justifies the imposition of punitive damages as punishment of defendants, and their callous disregard for the safety of individuals, including plaintiff, as well as to deter other similarly situated actors. So he's saying we need punitive damages. Like we're not even going after just hospital bills. We're going after pain and suffering, emotional distress, all this stuff. And the reason we're doing that is because it was so grossly callous of them to allow this to have continued to go on without doing anything about it. And then they're going to talk about the premises liability. So the liability of like Astroworld. Each of the defendants owned or were in total control of the property in question. Plaintiff, that's Mr. Guzman, was an invitee at the time of the injury on defendant's property, as they were concert goers at defendant's express invitation in order to make a profit off of them. Defendants owed plaintiff a duty. Now we're getting into duty, right? Duty, breach, causation, harm. We already have the causation and we already have the harm. He got a broken back he has a back injury. I don't know if it's broken. He's got the harm, got the duty, right here. We're getting to the duty now, but we already covered the causation. So let's see this duty. To exercise, just reading somebody else's comments. Okay. Duty to exercise ordinary care to keep the premises in a reasonably safe condition. They had a duty to inspect the premises and discover latent defects, to make safe any defects or give an adequate warning of danger. So this is just general duty. Defendants were also required to keep plaintiff safe from dangerous activities. And since dangerous activities were likely to occur at the concert, to take reasonable steps to prevent such activities or to take reasonable steps to make the premises safe. Defendants failed to exercise ordinary care in making the area safe or to warn of any potential dangers. Thanks, Naseeb. Oh, you cute unicorn. Okay. Because of the nature and severity of the injuries sustained, plaintiff has suffered disfigurement, physical pain, and mental anguish. In reasonable probability will continue to suffer disfigurement. Disfigurement, just so y'all know, is a specific legal word of art. It's not like this guy's just calling him disfigured. Like, if you can prove disfigurement, you can get more money. And I don't, as a disabled person, I do not like that terminology, but this is what they say. So I don't really, we can rally against that together because I don't like it either, but I'm just letting y'all know. Plaintiff has sustained very painful, disabling physical injuries. Plaintiff has suffered and will continue to suffer physical impairment, limitation of activities, and loss of enjoyment of life. Because of the action and the conduct of defendants, plaintiff's wage earning capacity has been diminished. So he's not even going to be able to do his job the same way anymore. Pre- and post-judgment interest. Plaintiff would additionally show that he is entitled to recovery of pre- and post-judgment interest in accordance with law. So that's just kind of more on the damages. He wants a jury trial. Okay. So, yeah. Okay. So that's that lawsuit. Again, that one isn't as big of a thing because it's just a TRO, like a temporary restraining order. So now we're going to get into this slightly longer lawsuit that was actually cited in Billboard. So let's just jump right into that so that I don't waste a bunch of time. Okay. So this one is against a lot more entities. We have Scoremore LLC, Scoremore MGMT Holdings, Sasha Stone Gutfreund, Live Nation Worldwide, Live Nation Entertainment, Live Nation Marketing, Daryl Platt, ASM Global Parent, Inc., ASM Global LLC, Mark Miller, Keith Butler, Trey Hicks, Jacques Webster, aka Travis Scott, and Cactus Jack Records LLC. Now, if you are here for the Lou Taylor content, then just know Cactus Jack Records LLC, the Texas company, does have as its address Lou Taylor's 9255 whatever West. We'll get into it so that I can show proof, but I don't want to get off this. I want to go through this filing first. Can y'all see this okay? I know sometimes y'all have a hard time seeing it. Okay, and who's our plaintiff? This is going to be Manuel Souza. It might be Souza. Sorry, I don't really know how to pronounce his or her last name. It looks like Souza. I don't know. I really don't know. Looks like Souza to me. Okay. Cactus Jack does have the TriStar address, the West Hollywood one. Plaintiff intends to conduct discovery under level 3. Okay, plaintiffs. Then the first is just going to get through telling you who everybody is. So we're going to just skim really quickly through this part. Plaintiff, Manuel Souza, is an individual who resides in Houston. Okay. The plaintiff may be reached through his lawyer or her lawyer. Defendant, Scoremore LLC is this company. Okay, we don't really need to actually go through any of this. This is just like necessary to put into the filing, but we really don't have to read it. If y'all want to read it, pause the video. All right, now they're talking about the jurisdiction and venue, which at this moment isn't like that big of a thing, so we won't go waste too much time on that either. Jurisdiction and venue is just you have to make sure that you're actually suing the person in the correct courtroom, the correct courthouse, and the correct state or city, and they're basically making their claims here that this is the correct place to bring this lawsuit. Now, let's get into the facts. On November 5th, 2021, a horrible yet predictable and preventable tragedy struck the Astroworld Festival at NRG Park in Houston. Defendants are the owners, operators, promoters, public relations representatives, and organizers of the concert and/or owners and operators of the premises. Defendants, individually and collectively, so each one all by himself or herself, and all of them together, both, right? Even if just one of them did it, it still would have been bad. But all of them did it, and it made it worse. All had and assumed the duty and responsibility for ensuring safe concert operations. Defendants, individually and collectively, further made representations to concert goers that safety and security are always our top priority, which seems now, looking back in retrospect, like it was a lie. And they would ensure safety. Sorry, I lost my spot. Ensure a safe, secure, and positive environment provided for all attendees, artists, and staff. Tragically, due to defendants' motivation for profit at the expense of concert goers' health and safety, and due to their encouragement of violence, at least 8 people lost their lives and scores of others were injured at what was supposed to be a night of fun. On November 5th, 2021, plaintiff, now this time this is Manuel Souza, attended the Astroworld Festival at NRG Park in Houston. Plaintiff paid for a ticket and legally entered into the NRG Park at the invitation of defendants. Okay, so they're saying, look, this isn't somebody that jumped a fence. He paid for a ticket, or they paid for a ticket, and they came into the thing, invitation of defendants, stuff like that. Plaintiff suffered serious bodily injuries when the uncontrolled crowd at the concert knocked him to the ground and trampled him. Plaintiff's injuries were the inevitable and predictable result of defendants' conscious disregard of the extreme risks of harm to concertgoers that had been escalating since hours earlier. Earlier in the day, concertgoers breached a security gate around the park, stampeded into the premises, and trampled over one another. Now, just content warning, there will be a picture coming as I scroll through the screen. I do not know what is on this picture. It is a black and white image. I do not know if it will be distressing, so I'm going to scroll past it as quickly as I can, but I just wanted to tell y'all. Oh, 2 pictures. Okay, so just so y'all know, I didn't realize this. This is my first time reading it. There are pictures. I try not to show the pictures on my channel, but they're in this filing, so there's not much I can do. I'm going to try and keep it as censored as possible. Later, several filings during the ongoing show performed by defendant Travis Scott on the evening of November 5th. I missed a sentence. Defendants made the conscious decision to let the show go on despite the extreme risks of harm to concert goers. Later, several times during the ongoing show performed by Travis Scott on the evening of November 5th, emergency vehicles literally drove through the massive crowd to render aid to concert goers who had suffered serious bodily injury. This was against a backdrop of multiple reports of tramplings, patrons losing consciousness, patrons being unable to breathe due to profound lack of crowd control, inadequate water, inadequate security, and lack of exit routes. Now, Fire Chief Samuel Pena would disagree. Fire Chief Samuel Pena said none of the exit routes were blocked off and there was plenty of ways to get out of the concert. Well, that's not what this lawsuit says. It says in black and white there was a lack of exit routes. And you know what's really weird to me? The first song that Travis Scott performed at this concert was called Escape Plan. Y'all already know how I feel about that if you watched my last video on this, which I posted this morning. Yet defendants made the conscious decision to let the show go on, despite the extreme risk of harm to concert goers that was escalating by the moment. Eventually, due to the defendant's active decision to let the show go on, the scene devolved into complete melee, resulting in the needless, untimely bleep of at least 8 people and injuries to scores of others. Okay, now there's going to be another picture. Just don't know what's on it. Just letting y'all know. This tragedy was months, if not years in the making. Okay, here we go. Now, if you watched my most recent video, you know I think the biggest thing they're going to have to show is, was this really preventable? Was this really, did they know? Did they know that this could have happened? And looks like this lawyer is about to argue, oh yeah, they knew. This was years in the making. On May 5th, 2021, in response to fan complaints about the concert quickly selling out, defendant Jock Webster, aka Travis Scott, tweeted, "We still sneaking the wild ones in." Okay, so someone had mentioned this tweet. I do see it here now. Are y'all saying that this is deleted now? We still sneaking the wild ones in. I don't know about this one. This recklessly encouraged fans to breach the barriers and otherwise actively encouraged a culture of violence. Okay, I don't know. Okay, all right. I'm as disappointed in this situation as the next one, but I'm not sure this tweet actively encourages a culture of violence. Like, you can sneak in non-violently. I don't think that's not your strongest argument, my friend. At the prior Astroworld Festival in 2019 at NRG Park, the same bum-rushing phenomenon was well documented, in which fans breached security barriers and trampled over one another to gain entry into the premises, resulting in injuries. And their footnotes are down there. This kind of behavior has long been encouraged by the festival's founder and main performer, defendant Travis Scott. Scott actively encourages his fans to rage at his concerts. His express encouragement of violence has previously resulted in serious violence at numerous past concerts. And then there's 3 examples here. First example, in 2015, he was arrested for disorderly conduct in Chicago for inciting violence at a concert by encouraging fans to breach barricades. In 2017, he was arrested for inciting a riot in an Arkansas concert, which I did mention in my video this morning. And in 2017, a fan was very tragically paralyzed at a Scott concert in New York City after a raucous crowd incited by Scott pushed the fan off a balcony. Now, I do want to also say Travis Scott in 2018 was also pled guilty for that second bullet point where he did incite a riot. And I can say he did incite a riot because he pled guilty to it. So maybe Mr. Or Miss whoever wrote this, y'all could put that right in the 4th bullet point in your amended complaint. Might help you. All of this was known to defendants at all relevant times and in no event prior to the time the first patron entered NRG Park on November 5th, 2021. Sorry, I just need a little sip. Okay. Defendants failed to properly plan and conduct the concert in a safe manner. Instead, they consciously ignored the extreme risks of harm to concert goers and in some cases actively encouraged and fomented dangerous behaviors. Their gross negligence caused Plaintiff, that's Mr. Souza, serious injuries. Plaintiff has therefore been damaged far in excess of the jurisdictional limits of this court. Now, I think you have to have like at least $75,000, like 75,001 cent to bring something into the district court under a federal court. I don't know. Someone who knows Civ Pro better than me, correct me in the comments. Okay, so now we're going to talk about the negligence of the defendants. Plaintiffs incorporate all other paragraphs. Plaintiffs would show, okay, it's 5.2. Plaintiffs would show, right, if this is allowed to go to trial, plaintiffs will show that the defendants had ownership and control over the instrumentality and or activities in question, and thus had a duty to exercise the degree of care that a person of ordinary prudence would use to avoid harm under the circumstances, similar to those described herein. Plaintiff's injuries were proximately caused by defendants' negligent, careless, and reckless disregard of this duty, okay? Y'all remember? Duty, breach, causation, harm. So the whole little thing is going to be them trying to prove there was a duty, they breached the duty, the breach of the duty caused the harm, and there was in fact harm, right? So he's saying, look, they were caused by the negligence, and that was the breach or disregard of the duty. The negligent, careless, and reckless disregard and breach of duty consisted of, but is not limited to, the following acts and omissions. And we have A through K on this page. Failing to provide a safe environment for concert goers. Failing to perform concert operations in a safe, reasonable, and prudent manner. Failing to maintain, follow, and enforce policies and procedures for safe concerts and concert operations. This sounds just like the last one, right? Failing to recognize and remediate known safety hazards. That seems like the breaching of the barricades and things. Failing to provide proper safe equipment and competent personnel. Failing to provide adequate security personnel. Failing to provide adequate medical personnel. Failing to institute precautionary measures to protect concert goers. Failing to maintain safety equipment in good working order. Violating industry standards and best practices for safe concerts, concert operations, concert ingress, egress. That means being able to get in and out of the concert. And concert crowd control. Failing to properly train, supervise, monitor, and retain employees and contractors. I'm feeling like they maybe didn't have enough security. Like, were they affected by the worker shortage? Then we have L through S. Failing to adequately warn or make safe dangers or conditions of which defendant had actual or constructive knowledge. Failing to use ordinary care as a reasonable company would under the same or similar circumstances. Undertaking duties to provide safe concert and safe concert operations and negligently. I wish they would have used the same font. Anybody else having trouble reading this? Because it seems like it's all different font type. To the detrimental reliance of concert goers. Dangerous and assuming a duty. Some of it looks closer together, some looks farther apart. To make safe, dangerous conditions on the premises and failing to use reasonable care in doing so. undertaking a duty to screen and vet concert personnel to ensure they were properly experienced, trained, and otherwise qualified to conduct safe concert operations, undertaking a duty to ensure that the concert was conducted consistent with safe operating practice, creating a dangerous condition and failing to prevent injury to others where it reasonably appeared or should have appeared to defendant that plaintiff, in exercise of their lawful rights, were likely to have been injured by creation of such a dangerous situation. Oops, sorry. And failing to correct, make safe, or adequately warn about the condition. And then the last one is such additional acts of negligence and gross negligence which will be established as the case progresses. So he's leaving open a catch-all category. Now he's saying, plaintiffs further assert the doctrine of res ipsa loquitur. Res ipsa, it speaks for itself. I think res ipsa is like the but for your negligence, it couldn't have happened. Somebody tell me if that's correct. Gross negligence of defendants. 6.1. Plaintiffs, 6.2. The acts or omissions described above, when viewed from defendant's standpoint, involve an extreme degree of risk, considering the probability and magnitude of the potential harm to plaintiffs and others. So basically saying like, it was so obvious, it was so clear that this was going to happen, that it's completely unacceptable. It's grossly negligent. It's not like, oh, oops, we messed up. We maybe should have been able to tell it was going to happen. This is like, no, y'all almost basically knew this was going to happen and still did not take the appropriate precautions. Plaintiff would further show that the injuries and damage that plaintiff sustained as a result of the incident in question were caused by the gross negligence of defendant, acting by and through their employees, agents, officers, and representatives, in the course and scope of their employment. Plaintiffs would further show that the defendant ratified and failed to repudiate their agent's gross negligence. So ratified and failed to repudiate means their bosses knew they were doing this. The security guard bosses and all these people, like the employers, the ones who were suing, they knew this was going on. Not only did they do nothing, not only did they just not do anything, but they like on purpose didn't do anything because they were doing it at the expense of people for profit. So yeah, exemplary damages. All right. So damages, this is going to be probably, content warning here, rough, because they may talk about what happened to the person. So just so y'all are aware, plaintiff seeks, I haven't read it. This is my first time reading it with y'all. Plaintiff seeks recovery of the following damages. Where a direct and proximate result of the occurrence made the basis of this lawsuit, acts and omissions outlined above. A, physical pain and suffering that will in all likelihood be sustained in the future. So he's saying, look, the pain I already suffered, plus I'm gonna have more pain in the future because now I'm, injured. Mental anguish sustained in the past. Yeah, I'm sure that probably thousands of people have some type of trauma, post-traumatic stress. I mean, people literally watch children bleep right in front of them. I don't think you ever get over that. So it's not difficult. If I saw it, I would have PTSD. Maybe I'm weak. Maybe I'm a little sissy, whatever. I would probably have PTSD if I was there. Mental anguish sustained that will in all likelihood be sustained in the future. Reasonable and necessary medical expenses that will occur in the future. Exemplary damages, I think that means punitive damages, like just to make an example out of this live nation so that nobody ever does this again. They should have to be paying more extra money as like a big fine, right? Any and all other damage to which plaintiff is justly entitled as shown through the course of this proceeding. All right. 8.1 says plaintiffs prefer, that's the people that are doing the suing, that the jury determine the fair amount of compensation for plaintiff's damages. So they're leaving it to the jury to decide. They're not going to sit over here and be like, we want $1 million. They're saying, look, let's let the jury decide. We'll just both present our expert facts and witnesses and accountants, and then we can decide how much the jury wants to award the plaintiff. It is too early in this case to be assessing the full nature and scope of plaintiff's damages. I can tell this is a Southern lawyer because I think if it was like in the East Coast, it would be like, it is too early in this case to assess the full nature. But they're like, it is too early in this case to be assessing the full nature. Like I can just like tell a Southerner wrote this, and I'm from the South, so I'm not being mean. Like I would say that like that. And plaintiffs place the decision regarding the amount of compensation to be awarding in the jury's hands. Rule 47 of the Texas Rules of Civil Procedure, however, requires plaintiffs to provide a statement regarding the amount of monetary relief sought. Accordingly, plaintiffs state that monetary relief of over $1 million is being sought. So they are saying, yeah, we are seeking over $1 million. Notice. Okay, that notice part is not. Okay. So this part is called a notice to preserve evidence. Now, the last lawsuit that we read, the one we read at the beginning of this live, is a different legal mechanism of doing the same exact thing, which is trying to get Live Nation and all these other ones not to delete or destroy any evidence, right? So instead of putting in a separate filing and calling it an injunction or a restraining order, they're just saying, look, you better preserve the evidence because you got sued already, sir, or ma'am, or people, or whatever, right? Plaintiffs request and demand that defendant and its agents, attorneys, insurers preserve, maintain, and place a litigation hold on all documents, communications, tangible things, and electronically stored information that arise out of or relate to the incident made at the basis of this suit. Plaintiff further requests and demands that defendant not destroy, alter, move, modify, reconfigure, replace, destroy, or discard any portions of the premises appurtenances. That's like buildings and different little things that are already on the premises, and any equipment that was involved in or present at the subject property at the time of the incident in question, and any other physical evidence, documents, communication, and electronically stored information related to the subject concern. Defendant should preserve all phones. I think this is supposed to mean tablets, but it says tables, and other electronic devices. Failure to maintain such items will constitute spoliation of the evidence and may subject defendants to sanctions. So if you allow your client to delete evidence, or if you delete evidence, you can be sanctioned as a lawyer. Defendant is required to provide all information or material described in Rule 194.2, .3, and .4 without awaiting a discovery request from plaintiff. They are also demanding a jury trial. And then here, look, they are actually asking the court for the same thing as the last plaintiff, which is a temporary restraining order and injunctive relief. So they are asking for the same thing as the last person, as Christian Guzman. Based on reasonable information and belief, plaintiffs assert that defendants may change, alter, destroy, or modify the evidence related to this tragedy. Pursuant to the Texas Rules of Civil Procedure, thank you, Nazika. Pursuant to the Texas Rules of Procedure 680, plaintiffs ask this court to issue a temporary restraining order prohibiting defendant from altering, moving, modifying, reconfiguring, replacing, destroying, and disposing of the subject premises and its fixtures, improvements as they existed on November 5th. Apparently that was also Kris Jenner's birthday. Can someone fact check that? I heard it was Kris Jenner's birthday on November 5th. Like, it was like a birthday celebration for her or something. Okay. Yeah, sorry. Anyway. Based on reasonable information and belief, where are we going? This evidence constitutes tangible, relevant evidence materially related to the incident complained of having injured plaintiffs. In order for plaintiffs to properly investigate and pursue their claims and recover damages and see that justice is done, this court should restrain defendant, its agents, servants, employees, contractors, contract employees, attorneys, affiliates, and those acting in concert with or in representation of said defendant. So that's Lou Taylor. You better not delete nothing, girl, because we're going to make sure people know that you are the business manager. A defendant is permitted to change, alter, destroy, modify any evidence related to this incident. Plaintiffs will lose the opportunity to inspect the evidence and will be unable to prosecute their claim. And as a result, the plaintiffs are going to be deprived of adequate remedies under the law. Defendant is incapable of responding in monetary damages if the evidence is not preserved. So they're just giving the reasons why the evidence should be kept and not deleted. There's no adequate remedy at law available to plaintiffs to prevent the defendant from changing, altering, modifying, or destroying evidence unless the court grants immediate relief restraining such conduct. So the court could reply to the first lawsuit, could reply to the second lawsuit, and it seems like if the court replies to either of those complaints, they're both asking for the same thing. Just please, Your Honor, make sure that Live Nation and all of their, employees and all of them, like, aren't deleting anything. Like, they're not deleting videos, they're not deleting texts, they're not deleting emails, et cetera, because we need all the information that we can get. And if they delete evidence, then it's going to make our case impossible to make. Okay. There is no adequate... Plaintiff prays that this court enter a temporary restraining order preserving the status quo by restraining defendants in any way from changing, altering, destroying, or modifying the evidence related to the injuries and fatalities arising from the concert, including, but not limited to, the subject premises, the fixtures and improvements as they existed on November 5th, including, but not limited to, the stage infrastructure, barricades, vehicles, permits, documents, electronically stored information, surveillance footage, and all equipment and appurtenances near and or involved with the incident in question until plaintiffs are given an opportunity to inspect all of the evidence. Plaintiffs also seek an order preserving any and all photographs and videos of the scene of the incident, parties involved, the premises and or equipment involved in the incident. Any and all documents or communications regarding the scene of the incident, parties, premises, and or equipment involved in the incident. Any and all documents or records relating to the incident, including but not limited to the OSHA records or records exchanged with any other governmental agency in connection with the incident in question. Any and all emails, electronic data, documents, statements, diaries, calendar entries, memos, incident reports, call slips, or telephone messages, text messages, faxes, voicemail messages, and correspondence related to the incident. Ooh, that's a big one. Any and all operational logs, inspection reports, operating manuals, actual audio recording, or any transcript of any recorded statements and mobile radio and dispatch records related to the incident. And finally, all permits, job safety analyses, site safety plans, site safety surveys, escape plans, which was the title of the first song that Travis Scott sang on the set, ingress, egress plans, emergency response plans, crowd control plans, permits, and other documents relating to the operations taking place at the time of the incident in question. So I do want to just make a small comment on this right here. It is interesting that the city of Houston is thinking about filing some type of charges against, Travis Scott and other people. This lawsuit's coming after the city too, because they're wanting site plans, safety surveys, escape plans, ingress, egress plans. Like, that comes into the city, that comes into the fire department. And that's why I am not going out of my way to believe these fire chiefs or these police officers, because they're the ones investigating themselves, but they're the ones being accused of not doing their jobs. So before I believe somebody was running around poking somebody with a needle, I'm going to need to actually see some people who were actually there, who are not in charge of investigating this negligence, who are not accused of being negligent. I want to hear it from an actual eyewitness who saw it happen. I want to hear it from somebody who's not in charge of investigating their own self for negligence about these poking with the needles crap. I don't think that has anything to do with anything. It's a huge distraction. I will not give credence to that theory until I hear it from a credible source. This tangible and physical evidence is relevant and reasonably necessary to determine the cause of the incident made the basis of this suit, the loss of which would irreparably harm the plaintiff. So he's saying, don't let them delete any of this stuff because we literally need it to make our case. Okay. Plaintiff further prays for this court to set a hearing on plaintiff's application for a temporary restraining order and subsequent injunctive relief on the matter. Plaintiffs also asked the court set its application for temporary injunction for hearing, and after the hearing issue a temporary injunction against the defendant as follows. So it's just a bunch of legalese, but y'all know what it's asking for. Plaintiffs also ask that this court issue an order that allows plaintiffs and plaintiffs' attorneys and investigative staff, including consulting experts, to have access to the incident scene. So they're asking the judge to let the lawyers go onto the scene and do an investigation with their experts. Where the injuries and fatalities arising from the concert occurred, we want to do that, they're saying, to inspect, photograph, and film the scene, as well as conduct necessary testing. Such access for the purpose of inspecting, photographing, and filming is essential in order for the plaintiffs to prepare their cause. The above allegations against defendant is made acknowledging that investigation and discovery are continuing. As further investigation and discovery happen, additional facts may be uncovered that necessitate further additional and or different allegations, including the potential of adding additional parties to the case. Lou Taylor, TriStar Sports and Entertainment. The right thing to do under Texas law, the right to do so is expressly reserved under Texas law. For these reasons, plaintiff prays that the court grant the motion for temporary restraining order and temporary injunction. Plaintiff further prays that defendants be cited to appear and answer herein, and upon a final hearing of the cause, judgment be entered for the plaintiffs. Actual damages above this jurisdictional minimum. Okay. So that's it. That's basically the lawsuit. What do y'all think? Yeah, I think Apple had drones recording the incidents. Yeah, this was a mass casualty event. Yeah, I mean, it is like, it's hard for me to think only 8 people lost their life. Wait, someone offered y'all a refund? They streamed the concert. Why is there a restraining order? Okay, great question. I've got words. So a restraining order in the legal sense can mean a few different things. And a lot of us, we hear restraining order and we think it means like a no contact order, like where somebody cannot like talk to you or be within a certain amount of feet from you or something like that. But really, it's a restriction on an action. So what we have here are these parties asking for the court to restrict Live Nation and the other defendants from being able to destroy evidence. So it's not a restraining order to stay away from someone. It's a restraining order to keep them from destroying evidence. Okay, thank you, Lilac. Fact check. Lilac says Lilac Gamer X, it is now being reported that there were 11 casualties or fatalities. 300 injured, but people could have complications and further complications later on. And like, let's not forget about the mental and emotional turmoil and stress that these poor kids are going to have to carry around for the rest of their lives. And even like if you're 27, you're still like a poor kid. Like you watch someone die in front of you at a concert you thought you were going to have fun at. Hold on, where's Steve? Steve says 8 dead today. What are the concert goers who are in the hospital? Yeah, exactly. That will be counted. Yeah, I don't know, Steve. Will it be counted later on, or like what's really going on here? There are lots of people still in the hospital. Everyone that saw that has a changed worldview forever, for sure. The medical workers who went through this deserve better too. Yeah. Because it's not their fault that like their bosses didn't plan accordingly, you know? Do I think a class action could be filed, or would plaintiffs have more luck filing individual lawsuits? That's a great question, Jay Stevens. It really depends on the actual damage to the plaintiff, right? So if it's like one plaintiff that has like really outsized injuries compared to the other plaintiffs, it might be best for that plaintiff to not participate in a class action. But if it's someone who has a lesser, and I'm not to minimize anyone's trauma on this thing, but it's all going to be relative to what people suffered within the class. So it really depends. Thank you, Be Botanical. Has anything been filed in Brittany's case today? Not to my knowledge, but I'll have to go and look. Let's see. Wait, okay, so how do they not know how to do CPR and check a pulse? Is that a thing that's been reported? I agree, Allison. I'm so sick of the investigators being able to investigate themselves. Why is this allowed to happen? And what can we do, if anything, to keep this from happening? Some cities do have like an accountability office or whatever that's like, outside of the main police or whatever, but I really don't know even if those are like legit. I'm willing to hear anybody else opinion on that. Like, what are some good ways to make sure that we're holding these folks accountable and they're not just investigating themselves? Like, oh, we investigated our own department, didn't find anything wrong, let's go back to business. Like, like, what are some good ways that y'all have seen it work? Okay, so Patrick is saying the show was not sectioned or vamped, which means proper distance from the stage and proper distance between each section of people. That is a big deal, in Patrick's opinion, based on the concert organizers' knowledge of danger. Thanks, Ricardo. Is there a Texas Bureau of Investigation or just Rangers? I don't actually know. Anyone from Texas have any insight on that? Apollo, yes, I will be at the November 12th hearing, God willing. I wonder, Steve says, about the folks who lost loved ones at the concert. Can they sue the government for not doing proper oversight, like not providing, thank you, Teresa, like not providing enough officers and health officials? Yes, Steve, they can. They can. And if anybody was like actually there, like witnessing that, then they can sue for like intentional, like infliction of emotional distress and all kinds of stuff. Like there's going to be a lot of lawsuits coming out of this. Oh my gosh. Wait, is this real? I have to look into this. There's reports of medics refusing to do CPR and asking audience if anyone knew how to do CPR. Where are those reports? Someone link that in the comments. Yeah, Be Botanical says to Steve, they can and they will. Okay, so we have Carol who says there was a concert goer that was pulled out, and when she woke up in the medical tent, she told them she was an ICU? I don't know what IUC is. Nurse, and she reported, well, she's a nurse though, so that's more than me. And she reported that medical staff were untrained and most did not know how to do CPR, I'm assuming is what you meant. So there is a video, Squidwin says. I have not seen this video, but Squidwin says there's a video. Security is waiting for cops. Then the cops are waiting for the EMS and no one is doing CPR. I don't know how to check a pulse or do CPR, but like if somebody was unconscious in front of me, I think I would just try it. Like just go for it. Like, Tracy said, I'm so sorry for that tragedy, Tracy. Tracy said that there was an incident with her son and it was investigated by an independent body, and that independent body was 80% retired cops. So that's that on that. Yeah, I've like intentionally tried not to watch some of these videos because I know it's super traumatic. New York Times reported that the medics refused to do CPR, according to Lilac Gamer. Discount medics just wearing the uniform without training. I wonder if Lou Taylor had anything to do with hiring them. Or Larry Rudolph, I don't know. Yeah, exactly. Like, I would just try something. Like, break the ribs. Who cares? Like, anything. Yeah, I would. You don't need to know how to check a pulse. Everybody knows. Just feel right here on the big vein, and it's like either moving or it's not. Thank you, Be Botanical. If you're licensed CPR, you are required by law to perform in the state of Florida, according to Be Botanical. They didn't have the right equipment, according to some of y'all. I did not see all of this stuff. Clearly they were saving money, Kat D. Kelly says. As a medical assistant, I like unicorn poop. That's such a cute picture. I know you can Google how to check a pulse and do CPR. Exactly. Like, you can Google, like, how to do CPR. Like, someone's dying. Like, what are you going to do? But again, like, it's not necessarily the concert people's, like, the other attendees' fault. It is the fault of the security, like, and the medics. Like, they should have been doing that stuff. Like, that was their job to do. I heard they only had 2 resuscitation machines. ICU means intensive care unit. Thank you. Yeah, this is really the issue for me too, DW. I read accounts also where the people said they were not standing on the floor. They were just standing on other people's shoes. So if that's the case, they were just moving as a wave, and then yeah, like, seeing an ambulance trying to get through that is just like, you have to stop the concert. I mean, you just have to. Lorraine, I am down. You know I'm down. Let's form a collection of law students and lawyers to investigate officials like police, firefighters, EMPs. 2021, Lorraine Moore. Exactly. Oh. Travis Scott posted his apology video. It was a pretty bad apology. I agree. Medical operations for Astroworld were overseen by Paradox Worldwide, who have been sued before, according to AR. Yeah, there is no way he didn't know it was happening. Like, they tried to claim. I mean, I guess it's possible he was on some type of, like, substance that maybe altered his perception. I don't know. I don't want to speculate, but from what it looked like to me, it's going to be difficult for him to say he didn't know what was going on, in my opinion. How Lou Taylor can still have clients is anyone's guess. Yeah, I mean, I guess he didn't really apologize. He, like, didn't actually say, like, sorry. He just was like, oh, I didn't realize, like, I never imagined any of this could ever possibly happen. Send your tips to the authority. Like, did he actually say, I'm sorry? I don't think he actually apologized for anything. Will Dinan read accounts detailing the lack of water stations. Apparently, only 2 noted stands in the venue. Others were unmarked. However, there were multiple stands selling water for $5 and cacti for $13. Oh, that is really a shame. Because, like, some of these folks might have been passing out because they were just strictly dehydrated. Like, if you can only get water for $5... I wonder if due to COVID, they may have been instructed not to administer CPR. Well, I don't know if that would be accurate, because I also, Nichelle, read reports that everybody had to present a negative COVID test to even get into the festival. So, I mean, I understand, like, COVID is, like, important and stuff, but, like, someone's, like, they need oxygen or they're going to die. I don't know. Maybe. I don't know anything about, like, medical, to be honest. Work in production for festivals and events, and everything about this makes me sick, says Amy. Jay Stevens, you are correct. Being impaired due to taking substances is not a defense. If it were, drunk driving wouldn't be illegal. That is true, but it might, you have to know that what you're doing could result in harm and injury. And I'm not sure he knew. I think he knew. It's my opinion that he knew, but we just can't be certain. So this is an excerpt, thank you, Celeste, from an article that cites the eyewitnesses. Teenagers are doing CPR, trying to help, but they're doing it incorrectly. Then I see there's other people doing CPR and people who still have a pulse because nobody has done a pulse check. Oh my God. Like, this is just too much. Yeah, you can have, yeah, no, right. Like, the COVID thing kind of starts to lose its force whenever you got 50,000 people that you let into this concert screaming and getting all close to each other. If unable to do CPR, always do chest compressions. With CPR, you can do it with just chest compressions if needed, because it kind of like pumps like your blood or whatever. Someone who knows how to do CPR, make us a video. Anyway, there's a video of somebody telling him there's tragedies, and he told them to F all that, and then they jumped into the crowd. Oh my God. Oh, some of y'all just doing a little bit much. CPR, you don't have to give breaths. People are saying you don't even have to do breaths. You don't even need the breath thing. People are saying you don't even need that. It's not even a thing. Sorry, I don't know. You think a pandemic would prevent an event like this? Well, yeah, you would think. The one thing for sure that had Tammy, this is gonna be the last thing. This is the last thing I'm gonna say here. I got other stuff to do. I'm really busy today, but I agree. The one thing for sure is that had he stopped a concert, brought full attention to the situation, lives would likely have been saved. And I'm going to say I agree with that completely. Y'all, I am learning about this case just as, in real time, just as y'all are. These documents, I just went and downloaded it myself. I kind of looked it up myself to try and see what was going on, because this is the only way that we can really know. Let's see what's going on in these lawsuits. Let's see what these allegations are. Let's keep holding these officials accountable so that they're not going to be able to cut any of this short. Let's make sure all the players who were involved in this are actually investigated. Don't leave anybody out who actually did help negotiate these things, who could have stopped this tragedy, who didn't. And, stick to the facts, because facts ain't defamation. Talk to y'all later. Love you, mean it. Okay, bye.